Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. Happy Friday! I'm recording this at 4:09 on Friday morning. I want to go over with you Brian's opening statement. I saw last night a bunch of people are doing his closing argument. I will cover that document. Yes, it posted on the 28th. But I thought it would be interesting for you to hear his opening statement as given by his attorney, Josh Martell, and also Sarah's motions that she filed last minute were denied. And I think the exchange between the judge and Sarah kind of sets the tone for what we're going to see for the rest of the trial. So I'm trying to break it up in segments that make sense. And I think this part, the beginning, makes sense. And then at the end of the video, I link it because what happens is this actually happened before Sarah's opening statement, right? Because petitioner goes first. So I just leave a link to the video for Sarah's opening statement in case you want to watch it again or you haven't seen it, etc. It was posted already to members with no commentary. And I think because the in link was so long, people were confused and thought the audio dropped out. But anyway, without further ado, I'm going to run the intro. Thank the members. Thank you for being here. If you like the content, please give it a thumbs up. And I hope to see you, around here soon. All you have to do is hit that subscribe button. You'll be, and the little bell post notification. You'll be notified whenever I post and you won't miss anything. All right, here we go. I'll see you on the other side of the intro. All right, I will be updating that on Sunday for all the new members because I know there have been gifted memberships and I thank you all for that. And thank you for everyone who bought me a coffee. There were so many this week. I am going to send you all videos, but I definitely appreciate your graciousness. Thank you so much. All right, let's get into it. This is the very beginning of the hearing or the trial, which I guess you know what I mean.
All right, my apologies to everyone here. A little bit technical difficulties. This is not my normal courtroom, and they've given me more stuff to play with up here. And I did not realize I had to do both of those. So, all right, go ahead and call the case.
This is the case of 2017 R166000. And please sing it. Judge Ortiz is on.
It's a little fuzzy. Swearing in, Brian.
I swear to affirm that testimony shall be the truth, the whole truth, and nothing but the truth. I do.
Ms. Boone, can you hear the clerk?
I'm sorry?
All right, the clerk is trying to do the oath. She's going to repeat it for you. You can sit down, sir. Great. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. All right, we're here for a final hearing with regard to a supplemental petition for modification of alimony and child support, as well as a petition for relocation. I do understand that there was a motion granting the temporary relocation, but it's my understanding the court needs to still consider a final relocation on that issue. Before we get into that, there were a couple of motions that were filed by Ms. Boone that I'd like to address before we start. The first of which is a respondent's motion for contempt and to compel petitioner to submit visitation application.
So I did do a separate video on this. She accused Brian of being in contempt of court, stating that in May 29th, when they had their final pretrial hearing, that the judge ordered him to fill out an application for visitation and that the judge gave him 2 weeks. We've gone over it numerous times. I put an excerpt up so you can actually see what the judge said. There was never an order. The 2 weeks were pulled out of thin air. this is again like my disbelief of her cognitive dissonance. I don't know if it's intentional or not, but obviously the judge can see that because they write up the minutes afterwards, so she can see that there was no 2 week anything in there, in the event that she can't remember it. Do you know what I mean? So I don't know what Sarah is trying to accomplish, like when she just tells these bold-faced lies. But I just, as a former auditor, if a person will lie to you about something that is so insignificant, they'll lie to you about anything, so they lose all credibility, right? So right out of the gate of this hearing, she's losing credibility because she's going to discuss it passionately as if it actually happened.
Immediately, that was filed with the court on August 20th of 2025. If I recall correctly, one of the last times we were here, the petitioner indicated that he had filed something with the Department of Corrections regarding the visitation. They were slow to react, and he was going to follow up. Did the court remember that correctly?
More or less. I had sent them something.
Hold on, Ms. Boone.
I never heard anything back from them about it. So I guess they never got that one. I have since submitted it.
All right, when did you submit something?
The end of last week.
You have a date you can give?
I think it was Friday.
Friday, which would have been the 22nd, I believe.
Correct.
All right, Ms. Boone, Mr. Boone has indicated that he attempted to follow up after one of our last hearings regarding the status of the application for visitation. He never heard anything, so he submitted another one on Friday, August 22nd.
Your Honor, am I allowed to expound on that?
Yes, you are.
Well, I know for a fact that I'm actually in the classifications department now, and as of this date, no visitation applications have been received on.
So she's not listening, right? Because this is Monday, August 25th, and he's saying he submitted it on Friday, August 22nd. Now, I don't know if he's able to submit it electronically. I don't think so, but feel free to correct me. I'm not afraid to be wrong. But let's just say he snail mailed it. It probably is just landing at the DOC on Monday or Tuesday, depending on how the mail works. If I send something to my mom in California, it's usually about 3 days. So maybe 1 or 2 days to get from where he lives in Florida to where the jail is, or the prison is. I'm not sure. But this is what I was mentioning before. Like, she has that Lori Vallow Daybell syndrome, where it's like she's not processing the information in real time. She has this script, she's probably rehearsed it with herself in the mirror over and over, and she just sticks to that script irrespective of what like new information is coming in. She doesn't receive that information. Check it out.
His end for himself or for my son. And no attempts also have been made in order for him to try to do so in the meantime. I know that our pre-trial conference was on May 29th, and you gave them a 2-week deadline to submit. And I believe also.
So here on the screen is the part where what the judge said: raised concerns, there was no pending motion, but petitioner did provide information to the court on his efforts. He advised the court he would attempt to follow up on the status. That was all that was said. But listen to what Sarah has. And I part of it is like, did the flying monkeys give that to her? But these are mailed to her. So she has read this for herself. So she is consciously making a decision to make up the 2 weeks, and there was an order, and there wasn't even a motion. So anyway.
So that his attorney even volunteered to submit them himself due to the prolongation of time for the now ongoing 9 months.
Now, I don't know what dictionary Sarah has, but the prolongation of time, why couldn't she just say the delay or the lengthy amount of time? She picked a $10 word for a 2-cent sentence. The judge's face. See, she doesn't really make any faces, but it's like, I feel like there is like a WTF kind of energy that she's giving.
I've been trying to get him to submit for no reason of him withholding submitting the visitation application. So that's why I put in my cross notice and again my motion for contempt at this point, because they have disregarded your verbal order or instructions to submit him within the 2 weeks as of May 29th.
All right, I'll have counsel respond.
Thank you, Your Honor. So in order for someone to be held in contempt, the court has to find that they willfully and intentionally violated an express and clear provision in a order or an agreement that was ratified by an order. I'm looking at paragraph 5 of the order that references this Department of Corrections application. And it says, respondent also raised concern about petitioner not preparing an application required by the Department of Corrections so that the minor child could visit her. There was no pending motion before the court on this issue, but petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application. There's nowhere in this paragraph where it gives Mr. Boone some sort of clear and express deadline to submit anything, or that he would be held in contempt or put on notice that if he didn't do something by a specific date, that he could be held in contempt by this court. With that being said, Your Honor, I do understand that it's the court's wishes, and it's my client's wishes too, to get this set up as quickly as possible. Mr. Boone has resubmitted a second time now the application on the 22nd of August, according to his sworn testimony. I'm assuming that whatever Ms. Boone is seeing right now, maybe it's not updated in the system. I don't know what else Mr. Boone can do to address this concern, but certainly being held in contempt would not be an appropriate remedy based on the language of the order in question.
All right, I will allow you to briefly respond, Ms. Boone.
Thank you. After the pre-trial conference, he also was under oath as well and told the court that he made an attempt, and he has not made an attempt. Nonetheless, that was 3.
So she's coming in hot with these accusations, right? She lacks the ability to show grace to anyone. And she probably lacks the ability to show grace to herself, to give grace to herself. But she's accusing him without documentation. And she just is like, doesn't give him the benefit of the doubt of maybe it did get lost in the mail. Maybe it didn't. Maybe Brian didn't care and didn't send it, and now he's covering, doing CYA. But when you're in front of a judge, you don't want to appear irrational. And she's acting as if she's peers with whoever is in charge at the correctional facility of handling these, right? Like she went over on her coffee break and asked them, chatted them up, asked them to look it up, and they confirmed. I guarantee you they probably feel harassed by Sarah as well, because I'm sure she's asking every day, every other day, have you gotten it yet? What have you gotten? What have you gotten? And then she's pestering Brian via tablet messages, more likely than not, about, well, who did you talk to? When did this happen? But if they didn't receive it, it doesn't matter who he talked to, right? Like she's basically saying either he's lying or the correctional officers are lying. But the main thing is we're here today at the trial to decide the parenting plan. So what comes out of that will be, yes, there's visitation, so then he'll have to do it. There will definitely be a court order, right? If he's agreeing to 1 month of visitation, he's got to do some work on his end to facilitate that. But she is so short-sighted of like, he didn't do what he was told, even though he wasn't told in the way that she's reporting it. She can't see the forest for the trees, right? She would have come in a much better position of power had she not brought this contempt. And what does contempt look like in this situation? She wants to ding him for civil, like for monetary penalties. So again, trying to take money out of his household. The money doesn't go to her. I don't think she knows that, but it's like vindictive for everything you've done to me. And I feel like he's done so much, and you'll hear above and beyond what has been required of him. And she has shown zero gratitude. She has given him zero grace. She is just brutal. I don't know what other word. Brutal, disconnected from reality. Like, she's exactly where she's supposed to be. She doesn't belong out here with the rest of
months
us.
ago, and you did give them verbally a 2-week deadline. And again, verbally, his counsel volunteered to.
Right, Ms.
submit the
Boone, I
application.
cannot enforce any verbal statements that were not in an order. I specifically put in the order because there was no motion at the time. We did address it, and I did want there to be note that we addressed it, but there is no specific order requiring Mr. Boone to do anything by any specified period of time. And by law, because there is no order, I cannot hold him in contempt for
Okay.
a failing to comply with an order.
Is there a way that, it's been 9 months that I've been asking from him to submit these visitation applications. There's no legitimate reason for him doing so, and I don't have any record of who he spoke to supposedly.
There's no legitimate reason for him doing so. He hasn't done anything. So what do you mean for not doing so? And again, we're here today to decide what the final picture looks like. So let's stop arguing about this and let's get on to why we are here.
When he did try to contact DOC, and then also a confirmation that he's done it this time, 9 months later and under oath. How?
And I don't know why she keeps saying under oath. Like, again, unless it's to just to call him a liar, right? He's under oath. Because she'll say it during the trial too. You do know you're under oath. But a person who lies all the time always thinks everyone else is also lying all the time.
How can I go about doing so to make sure that this is actually being done?
All right. That I am going to deny without prejudice the motion.
And you see how she ends it with the question. The judge is like, okay, and she's just going to give her ruling. She doesn't have to answer that. Because no one is clear on why you need all of this, except that you have a lot of free time.
For contempt, I do not find that there is any willful.
Let me go back. She's denying.
For contempt.
For him doing so. And I don't have any record of who he spoke to supposedly when he did try to contact DOC, and then also a confirmation that he's done it this time, 9 months later and under oath. How can I go about doing so to make sure that this is actually being done?
All right. That I am going to deny without prejudice the motion for contempt. I do not find that there is any willful violation of a specific court order with regard to a visitation application. All right, there was another motion that was filed by you, Ms. Boone, respondent's motion to appear in person for trial that was also filed on August 20th. I will hear you on that motion.
Well, I'm on the telephone, so it does me no good at this point, Your Honor.
All right, are you withdrawing that motion?
I am.
All right. All right, hearing that you're withdrawing that motion, I'm going to deny that motion as being moot.
So I think, well, one, she has to address all the motions, but I do believe like Sarah could have had an opportunity to say, no, I want this to happen. And it would just delay the hearing. Like they'd have to figure it out, and whatever issue the DOC was having, they'd have to figure it out. I will say I went back to her family court trial and they did, well, not they, let me be specific. The Orange County Jail did transport her for her prior hearings, obviously when she was local to the courthouse. But now that she's gone, it's obviously up to DOC, right? The state prison facility, and they were denying it because it, probably not in their budget. Probably not their problem that Sarah has dragged this out, because had she just agreed to some of these things, we would not have to have what we're watching right now. And the petition for relocation, the temporary, was from 2023. We're in 2025, obviously, right? She had 2 years to agree to this, but you'll see she's going to agree to it on this day. And it's the first time Brian and his attorney are hearing of it. So it's like maybe wants the judge to witness it. So the judge is kind of replacing the police, right? Like in her scenarios with George, whenever George didn't do what she told him to do, she called in a higher authority. This is what she's doing to Brian, except it's Judge Jackson instead of the boys in blue.
Now we can move on to, with regard to the petitions that we're here on today. And I'm going to start with the petition for relocation. Ms. Boone, do you oppose the petition for Mr. Boone to relocate with the minor child to Florida?
I do not oppose.
All right, hearing that there is no opposition, I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to Florida, and hearing no opposition to the motion, the petition for relocation, I'm going to grant that petition.
Your Honor, am I allowed to say anything in regards to the contents of?
If you're not contesting it, I don't need to hear anything about it.
I am contesting some of the points that they have in regards to some of their other motions and modifications. Just things that I would like to apply to it from this motion.
All right, the petition for modification is solely for Mr. Boone to move to Florida with the minor child. Are you opposing him moving to with the minor child?
Your Honor, you said the petition for modification, the petition for relocation.
Excuse me, the petition for relocation. We're not dealing with the petition for modification just yet.
Okay, no, I do not oppose the modification for relocation.
All right, so as I stated before, I'm going to grant the petition for relocation.
So she's just agreed that she's not opposed. They didn't need to be in front of a judge for her to agree. She could have agreed to that back in 2023 when they were still with Judge Michael Dean. She refused, and she had no good reason. Like, she couldn't articulate why she didn't want them to move. She would just go back to, well, the court order is it can't be beyond 50 miles. Like, not computing that the circumstances had changed, and at that point it was temporary, and she hadn't been convicted at that point, to be fair, so it was temporary. And then it was like, well, once she was like, let's just give her all the benefit of the doubt, right? Let's just give her all the grace in the world. If she were worried that once she was found not guilty, sorry, it's laughable, once she was found not guilty, that they were so far away she couldn't get to them, it was temporary. And so then she could go back and have it canceled, right? But after, when was she found guilty? October, what was it, 25th, I think? Yeah, the 25th, because it was the Friday, and then her son's birthday was that Monday. After that, she could have come forward and say, okay, I no longer have any issue. It can be permanent. But no, she waits until the middle, almost the end of the year. It's almost a year later since she was convicted, right? And now she's announcing it. Not directly to Brian and his attorney. Didn't give them a heads up before. Didn't send anything in writing. We know she knows how to write a letter. But now she's agreeing to it. This is what has added up the attorney's fees, right?
Petitioner's verified petition to relocate that was filed on February 14th of 2023. All right, that puts us to the petition for supplemental petition for modification.
Your Honor, if I may just have one question about the relocation petition.
Okay.
Does Ms. Boone also agree to adopt the proposed amended parenting plan that we submitted in regards to the relocation? Because that is still.
Okay.
I just need to know if I need to present evidence as to that point.
All right. So we will hear evidence with regard to the parenting plan as it relates to both the verified petition to relocate and the supplemental petition for modification. All right. Do we wish to have brief opening statements?
So really fast, there are 3 parenting plans. The original parenting plan, the parenting plan that was submitted with the temporary relocation, which is now just gone to permanent. So she's agreeing to the relocation. She's not agreeing to that parenting plan. And then there's a 3rd parenting plan that you and I recently went over. And it is the one for going forward, right? That includes that she's incarcerated for life, or the temporary one, the one that was affiliated with the temporary relocation request, she's still pending. She's still waiting for her child. But the most recent one, we know she's doing life. So, but she right away is like, that parenting plan I'm not agreeing to.
I'd like the opportunity, Your Honor.
All right, so Ms. Boone, I'm going to hear brief opening statements first from the petitioner, and then I'll hear your brief opening statements. And again, we're only dealing with the issues on the supplemental petition for modification of alimony and child support. And I believe also,
Real quick, you guys can see there's Hear Me Out over here. Edie Beatty is here. HRH Mom is here. And Larry is here. This is the woman, I think it's like an Italian screen name, or Luminessa, I think. And then you can't really see HRH's husband, but he's behind Edie Beatty. Oh no, actually here, he's over here. This is before I arrived because I end up sitting there. Just if you want to get the in the room feel. And you can kind of see Brian's far away, but he's thinned out. He just seemed lighter in his loafers. Do you know what I mean? Like a little less burdened. I think just getting to this point was significant for him. Yeah, he just seemed lighter. I don't want to say he was flipped, but it was he was very candid while he was talking to his attorney and just in the court in general.
you all wanted sole parental responsibility, is that correct?
Yes, Your Honor.
Okay, I'm going to go back.
All right, do we wish to have brief opening statements?
I would like the opportunity, Your Honor.
All right, so Ms. Boone, I'm going to hear brief opening statements first from the petitioner, and then I'll hear your brief opening statements. And again, we're only dealing with the issues on the supplemental petition for modification of alimony and child support. And I believe also you all wanted sole parental responsibility, is that correct?
Yes, Your Honor.
And then also the proposed parenting plan with regard to the relocation. Okay, once counsel for petitioner has done with their opening statement, I will give you an opportunity to also present an opening statement, and then we'll go right into evidence, okay?
Yes, Your Honor.
All right, I will hear petitioner's opening statement.
Do you mind if I go to the podium here?
You may.
All right, well, good afternoon, Your Honor. We're here today, as you've already outlined, on a petition to relocate and a petition to modify. I can cut out a lot of my opening statement because it sounds like Ms. Boone has agreed to the petition to relocate. What the evidence is going to support and what we're going to
So again, I just can't stress this enough because I know we're going to come down to attorney's fees and some people are going to be like, well, why should she? But do you notice he just said I can cut down on my opening statement because it sounds like Ms. Boone has agreed to the relocation. So he has spent time writing up points on that, right? And probably has evidence ready to support that relocation. So had she at least even told them a week ago, he might not have had to spend that time. But guess what? He did spend the time, and guess who it's billable to? Brian. Like, this guy's not working for free.
what we are going to present evidence on regarding the parenting plan for the petition to relocate is that we are proposing that Ms. Boone have a 1 monthly visit with their 14-year-old son at the correctional facility that she's located in Marion County, and that she be also entitled to a minimum of 1 weekly phone call with the child. And we are also asking for sole parental responsibility regarding the day-to-day, or not only the day-to-day decision-making of regarding the child, but also all of the decisions related to the child. We believe the evidence in this case, considering what has transpired since February of 2020, would support a order of sole parental responsibility when it comes to parental responsibility. I think the most contentious part of this case, Your Honor, is going to be a discussion regarding whether or not Ms. Boone is owed money. Our position is that, Your Honor, actually Mr. Boone is owed money, but he's willing to waive that and just to have both parties owe each other nothing moving forward. What evidence is going to show, Your Honor, is that since February of 2020, Ms. Boone has been incarcerated. She was charged and arrested for second-degree murder and has since been convicted by a jury of her peers of second-degree murder in December of 2024, and she is serving now a life sentence. Since February of 2020, Mr. Boone has been 100% financially responsible for their now 14-year-old son. At the time that Ms. Boone was incarcerated, what evidence is going to show is that Mr. Boone stopped paying the $1,000 per month of alimony and the $100 per month in child support that was ordered pursuant to the June 15th, 2018.
One thing, sorry, I just noticed Brian and this gentleman have the same. They're like resting. This is not the son, and I've taken the son's name out. I've taken the city where they are out, and I've taken the name of the school where the son goes out just for his own anonymity as much as possible. I know it's out there. I just don't want to add to it. This is Josh Martell's brother, and he's funny. I don't know. His expressions were funny, I should say, because he would turn to the side. I was pretty much sitting behind him once I got there. But that's the brother. That's not the son. One of you guys asked in the last video. Or maybe it was on the members video.
In final judgment of divorce between the parties. Mr. Boone will testify and evidence will support that for multiple years after the respondent was incarcerated in February 2020, Mr. Boone continued to give Ms. Boone financial assistance in the form of commissary payments, other payments, and also maintained a mini storage for her for multiple years after she was incarcerated, despite having absolutely no legal obligation to do so to maintain that mini storage. What evidence is going to show is that when she was incarcerated, actually, Mr. Boone.
You hear that, Sarah? He had no obligation, and you are thankless. You are ungrateful. You talk to him like he's a thing to be stepped on, and he is the only one in your life who was delivering for you in your time of need. Can you muster a kind word for him? Not that we've seen. It's more.
Help her remove her stuff from the apartment that she was living in at the time, and was really one of the only people that assisted her during that time and acted in good faith to help the mother of his child during that time period. What Mr. Boone is going to testify to is that throughout that time period, he averaged about $600 a month in direct payments to Ms. Boone and also in-kind payments towards expenses that should have been Ms. Boone's obligation. Also, what evidence is going to show is that since February of 2020, Ms. Boone had approximately a $370 child support obligation to Mr. Boone. And the reason why we believe evidence will support this is that under Florida Statute 6130, subparagraph 11, subparagraph C, despite the fact that the petition to modify was filed in April 12th, 2022, that the court is within its authority to modify child support retroactive to the date a parent first failed to exercise their time sharing pursuant to the final judgment. Ms. Boone, pursuant to the final judgment, had an equal time sharing schedule, and then, of course, in February of 2020, that time sharing went down to 0, and she had 0 overnights. She's had 0 overnights ever since. So therefore, the court can go back to February of 2020 and consider what the child support obligation should have been, considering that she did not exercise her time sharing, and give Mr. Boone a credit for what the child support should be. And we'll be presenting evidence as to what we believe that number should be.
So that is really key, right? So you and I, we've talked about how his alimony he's technically responsible for until he filed that motion in 2023 to eliminate or reduce, right? But the child support, it doesn't have to do with any motion. It goes back to immediately when she was in breach of the plan, of the sharing plan, which obviously was the 25th of February in 2020 when she got arrested, right? So immediately she owed him money because it was just like out of the blue, right? Who was expecting for her to be arrested and be there? I mean, now 5 years later, and now we know for the rest of her life. So he had to figure everything out as far as, even though she wasn't reliable when she was doing timeshare, right? They're gonna get into that when we get to Brian's testimony, but at least there was the option, there's the potential for her to watch the child. Now it was completely gone and it all fell on Brian's shoulder. So think about that in context in addition to he took on responsibility for her things, making sure she was fed, and she just never is grateful. That part I don't understand, but that's important. And they came up with that number. We did go over that in a video I got a lot of heat for, where Brian imputed $60,000 for himself annually, and I felt like he lowballed it. It's neither here nor there. And then he imputed minimum wage toward her, and so that's how they came up with the 370. But I think that is key, right? So if she owes from there until, I don't know how they figure out the end date, or if they figure out the end date, because he was saying, the lawyer Martel was saying earlier, like, let's just have neither one owe anything and move on. But if they put that dollar amount, they put the lawyer's fees in there, that offsets the money, the alleged, well, it's not alleged. He owes her that for the first 2 years, but it offsets it. So that's why I was saying on paper, he'll owe her, but she'll never see a dime, in my opinion.
Imputing minimum wage to Miss Boone and also imputing $60,000 a year of income to Mr. Boone, despite the fact that he's currently unemployed. Also,
even there, he threw her a bone because he is unemployed. He could have put 0, which would have made her number higher, right? But he doesn't. He was like, if I'm working, this is what I'm making. Let's just put this down.
So, Mr. Boone, since Miss Boone was incarcerated in February of 2020, has accumulated over $14,000 in attorney's fees trying to modify the final judgment and trying to be able to successfully relocate his son to Gainesville. This morning was the first time that Miss Boone has made any concessions regarding any of the outstanding motions that were filed by Mr. Boone and the petitions that were filed by Mr. Boone, despite having really no articulable argument against the relocation. And the court should note that.
So the first time in 3 years, because he filed his modification in 2020, right? The first time in 3 years that she's made any concessions.
In the order on temporary relocation that was entered by a predecessor judge in this case, articulated that Ms. Boone, even at that hearing, seemingly had no articulable reason to object to the relocation, yet she still has forced this final hearing and forced Mr. Boone to incur attorney's fees for another 2+ years while we continued to litigate this matter. So another thing that we believe evidence will support and what we're going to be requesting here today is that the court take into consideration in its equitable powers the amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Miss Boone's voluntary criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation, which has had a direct result in Mr. Boone having to incur tens of thousands of dollars of attorney's fees. And so if there is, even after the consideration of the payments that were made to Mr. Boone, from Mr. Boone to Miss Boone during the period after February 2020 moving forward, the retroactive child support that Miss Boone ordered, if there still is potentially a retroactive alimony amount this court is considering, we are asking that the court also in its equitable powers, consider the $14,000 in attorney's fees that Mr. Boone had to occur, and that the court would apply that to any potential technical arrearage that Mr. Boone might have. And when we say technical arrearage, Your Honor, technically speaking, while child support is retroactive can be retroactive to the date that a parent stopped exercising their time sharing, alimony modifications are only technically speaking retroactive to the date that a petition to modify was filed. And so we're looking at that basically 26-month time period between February of 2020 and April of 2022 when modification was filed. It's also important to note, Your Honor, that evidence is going to show from the date that that petition was filed moving forward that it is appropriate to terminate Ms. Boone's alimony obligations, obviously, or alimony award, excuse me, because she has no need for day-to-day living expenses when she's incarcerated and having the state pay for her day-to-day needs.
Woo, he said a mouthful. So I just really quick. So he is adding in the child support that she would owe, the money that he spent, the attorney's fees, right? So he's kind of giving the judge a buffet. You can pick here, you can pick here, you can pick here, you can pick all of them to offset this. I love that he said, she's a ward of the state and she's being taken care of there. Again, she doesn't process it. You'll see when he questions her, her only reasoning is because it was ordered in 2018, not processing that so much has changed in their circumstances since 2018. And then, there was one more. I should be taking notes. Let me just go back really fast. Let me see.
Potentially a retroactive alimony amount.
I know what I was going to say now. And this is, so because it would be retroactive, right, where he's saying about the elimination, this is where a lot of people got confused of like, well, it doesn't say he doesn't have to pay, but it's implied because, say, for example, he had continued to pay her while the motion was pending and then he wins the motion. Is she going to give him back the money? No, because she would have already spent it, or in her mind, it's hers. And so that's why it's set up that way. And that is why her motion for contempt for non-payment could not be heard until this motion, which we're doing now today, was heard because he filed first. Now, had it been in reverse, had she filed for contempt, let's say in 21 before he filed, then yes, her motion would have been heard first. He would have been found in contempt because he wasn't making it. So hopefully that puts that, because so many people have said, well, it doesn't say that he gets to stop. It's implied. And it's not that he wouldn't owe her. If he lost his motion, he would owe her that money. And then at that time, he would pay it. But it doesn't make sense for him to keep paying it while that motion is pending, because if he wins, there's no way for him to recoup that had he been paying. Does that make sense? Hopefully that makes sense.
This court is considering. We are asking that the court also, in its equitable powers, consider the $14,000 in attorney's fees that Mr. Boone had to occur, and that the court would apply that to any potential technical arrearage that Mr. Boone might have. And when we say technical arrearage, Your Honor, technically speaking, while child support is can be retroactive to the date that a parent stopped exercising their time sharing, alimony modifications are only technically speaking retroactive to the date that a petition.
I sped it up. If it bothers you, you have the same controls that I have on YouTube, and you can go in and go under playback speed and slow it down to whatever your heart desires. And you don't have to tell us about it in the comments.
To modify was filed. And so we're looking at that basically 26-month time period between February of 2020 and April of 2022 when modification was filed. It's also important to note, Your Honor, that evidence is going to show from the date that petition was filed moving forward that it is appropriate to terminate Ms. Boone's alimony obligations, obviously, or alimony award, excuse me, because she has no need for day-to-day living expenses when she's incarcerated and having the state pay for her day-to-day needs. And so it is appropriate to terminate alimony from April of 2022 and also to give Mr. Boone a credit. And we'll be presenting evidence on that. Also, we're going to be presenting evidence, Your Honor, as to a sum of money that is currently being held with the Orange County Clerk of Court. It's over $4,000 in child support and alimony that's being held that has not been released to Ms. Boone. And we're asking that the court order that money be released to Mr. Boone so that he can use it to help raise their child that now he is unfortunately having to raise completely by himself, both physically and financially. Lastly, Your Honor, there's been some motions filed, and this was mentioned in Ms. Boone's pretrial memorandum, so I'm assuming it's going to be brought up here today. Ms. Boone is alleging that Mr. Boone is unlawfully in possession of some personal property of hers. There is no court order that Mr. Boone is in violation of regarding that, but here's what evidence will support, and here's what Mr. Boone is willing to do, is that he does have, when he finally stopped paying for the mini storage, Your Honor, he did move items out of the mini storage to his home that are Miss Boone's personal property. He still has those items there. And if Miss Boone has any relative that wants to pick those items up, he has them packed in boxes, and he will be testifying that he has no objection to releasing those items to a family member of Miss Boone. Thank you.
Before you give Ms. Boone, am I understanding that petitioner concedes there is 15 months of alimony that should have been paid? And so there is a amount that's owed, I believe it's $1,000 per month, so that would be $15,000?
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
Okay. All right, Ms. Boone.
Judge was like, listen to what I am saying. So I'm not sure how she got 15. I think we got like 25. I can't remember because it's almost 2 years. And I'm not sure why they are counting February, because per the order, the payments are due on the 1st of each month. She was arrested on the 25th, and February, it was a leap year, but there was only 4 days left to that month. So he didn't owe for February. But if you guys let me know how the judge got to 15 months, because I've racked my brain and I'm not sure. But so starting from April Fool's Day until when he filed, which I believe was in April, yeah, I got 24 months. But listen, if everybody agrees to 15 and Sarah's not objecting, more power to Brian. I'm going to give him all the grace in the world because he deserves it.
Do you wish to make a opening statement?
I will do my best, Your Honor.
Okay, so that was it. Members, I added this here because this is a link to the video where Sarah gives her opening statement. So I didn't want to be repetitive and put the opening statement here again. So I'm just redirecting you to the video where the opening statement and my reaction and my notes on her case are already in a video for you. So hopefully that makes sense. I probably should have done an audio on there so it would be not confusing. Anyway, that was the very beginning of how that all started. And there's a little bit more because there were some issues with Sarah in the beginning, and there was like a CO talking to her, but I started to put it in, and then I was like, it's hard to tell who is who. Anyway, that's how it started. That was the jump off. Then we went into Sarah's opening statement. So next I'm going to edit out the name of the child, the school, etc. for when Brian testifies, right? He's a witness for his own case, and it's juicy. But so now we've learned Brian was paying $600 a month for her storage. He was sending her money every month, and they had some sort of agreement. It never really is clarified, or at least it's not clear to me. Maybe you guys, when you listen to it, you'll pick up things that I missed, and you can help us out in the comments and explain it to us. But he's been kicking her ends, the whole time. You'll hear like when he stopped, why he stopped, and it's nice to hear his side because he wasn't responding to the text, so he couldn't really get his side, and Sarah's side is filled with like such vitriol that it's hard to discern like, well, what's real, what's not. I think maybe 2% of what she says is real about Brian. Now I don't think he was ever like disparaging her or making the comments that she claims he was making. So yeah. All right, so the next video you get from me will be the closing arguments for Brian, because that one is already ready to go. And I'm just going to read it and explain it and give you my feelings. And then we'll go back to trial footage, just so I can keep things moving, because I know you guys are waiting and I'm doing my best, I promise. And I'm trying to catch up on Adelson. So, I'm sure you guys are watching that. That's a little juicy. I've got body cam footage of Charlie. I'm overlaying all of his wiretaps on there. Man, that boy can talk. He talked himself right into life in prison. But that's another video for another time. I appreciate you all for being here. I look forward to talking to you in the comments, because we have been waiting for this and it is juicier than I ever imagined it was going to be. And Sarah is crazier than I could ever fathom. But surprise, surprise. Where's Gomer? Wait.
Surprise, surprise, surprise.
Woo! All right, I'll talk to you later. Toodles.